Hey, real deal. How y'all doing? Hope everybody okay. If right, we're gonna get into our reaction this evening. The boy in the box, Timothy Firriter, um, trial. What happened in the jury deliberation? Something happened in the jury deliberation, and we need to find out. Okay, hold 1 second.
Firriter case. Maybe I should call it a big faux pas in the Firriter case, because the question from the jury is more of an alert to the judge that the jury got evidence they weren't supposed to get. They reviewed videotape evidence handed over by the defense. So this is a defense mistake. Video evidence they were not supposed to see. It shows the child victim in this case being handcuffed, which is protocol with police with a child runaway. But if you don't have that context, it looks like the child's being put under arrest. The jury wasn't supposed to see that. Let's go into the courtroom. We're going to rewind the tape back so you can hear the moment when the judge learns of this big blunder.
All right, I'm advised that the jury has apparently had a piece of evidence reviewed that was not in evidence. I don't know how that happens, but it apparently was the arrest of the defendant. So let me hear from, excuse me, the victim. So how did this happen?
I don't know, but they put into Your Honor ruled that they could just put in a picture of him or like a showing what he looks like. And on the USB that they put into evidence is 2 files. And then the other one also says he's going to be arrested, and they said that they published that. We went and published this.
There's been no publishing of an exhibit where he was arrested, the victim?
What happened was we had a video. He was originally in school. We went sidebar. The court said we could play a trimmed version of it that just shows what he looked like at the time on that date.
That's right.
And we trimmed it. However, inadvertently, when that jump drive went into evidence, the longer version wasn't deleted out. So there's 2 files on there instead of just the one that says trimmed.
So how does that happen, Mr. Wahid? Isn't that on the defense? That was your exhibit. You were required and responsible for making sure that what was admitted in evidence and what was published was to be on that thumb drive. And now I'm hearing that they have seen something that was not admitted into evidence?
That is all correct, and it is our responsibility. I'll take responsibility for that. That was the day. That was the first day. It was a very, very busy day. As we moved through the day, it was completely inadvertent.
No excuse.
I think I did the crosses for everybody that day, so I didn't really look at that evidence at the end of the day when we were trying to get it to Madam Clerk. So that was a mistake.
All right, Ms. Coakley, what's the state's?
I think it needs to be an instruction to the jury to disregard it, and it also is factually inaccurate what they had it characterized as. He wasn't arrested; he was just detained and never arrested. So to indicate that he was, like, there was just police procedure that he was detained for a moment when it cuffs. There was no arrest here. So to indicate that he committed some type of crime for which he's arrested now, based on how they labeled this, which they provided to the jury, is really problematic. And they had to play it without any sound. I had to play a video without any sound because unfortunately I advised him that and he didn't send that back.
Well, to say that I'm displeased with this development would be a massive understatement. This trial is, we're in the 9th day. I rely on the attorneys to make sure that the evidence they submit, and based on my rulings, properly reflects what my rulings are and that the jury sees only what has been admitted into evidence. Let me hear your position, Mr. Wahid, on the state's request for limiting instruction. I assume it's going to be something to the effect that, well, one, the exhibit's got to be corrected. The proper file has to be put on the thumb drive. Secondly, it would be an instruction that to the extent that they have seen documents or videos that were not received properly into evidence, they're to disregard that. And also, your concern is about the nomenclature of the file name, right? Okay. Your response, Mr. Wahid.
just to be clear, the right evidence is on the thumb drive. It's just that the untrimmed version was still left on it. So
They
I just
know
want to,
that.
How can you say that? If you say the right evidence is on the thumb drive, and now I'm dealing with a situation where the jury's reviewed something that they were not supposed to have reviewed, which was not in evidence, and then those two things don't mesh with me. I mean, either the pared down video is on it or an improper video that includes something more is on, right?
both on it. That's my point. That's all I'm trying to just say. So I agree with the state that the longer version needs to be deleted. I also agree with the state that my recollection is the court's ruling was to play it without audio. So it would be something that doesn't go back to the jury, that they would have to play out here without audio, just like one of the state exhibits. I also agree on a limiting instruction.
Okay. All right. So, Mark, I want you to retrieve the thumb drive that they were reviewing.
State has it.
Oh, you already have it?
Yeah, and the state's also asking for a factual stipulation, because it creates, what is on
Lord.
the scene is him getting handcuffed and led to a police car. Which is factually false. He was detained because he ran away.
Well, I thought that I heard Mr. Wahid not object to my limiting instruction where I would advise the jury that the victim was not arrested. He was just simply detained as part of the normal practice in dealing with runaways.
That's correct.
All right. You can go ahead and bring them out.
Give me a moment, Judge. We're just going to fix this.
Okay. Well, that doesn't need to wait. You can do that and not take up the time of the jury on that.
Here.
And we are waiting for the queuing up of the replay. You may bring them out.
But I be trying to make that little boy look bad.
Oh my. Oh my. I mean, this is so bad. What
It's
just
bad.
happened is so bad on so many levels. I guess I could call it carelessness.
Yeah.
I mean, the attorney's apologizing, but how does this happen? As the prosecutor said, with even the labeling being inaccurate, the labeling, calling it an arrest, which it was not, a detention's very
That's right.
different.
See, what they were doing was trying to, what the defense was doing at the time, what the defense was trying to make the little boy look bad. That's what he was doing. He was trying to make the little boy look bad. And like the boy got locked up. Oh, I tell you, this ain't good. So y'all, I let y'all know the verdict. Let me see, can we get to the verdict now? This is terrible. Let's go to the verdict, because they are doing too much. I tell you, I knew something was wrong. I knew something had happened. See, I knew it. I knew something happened. Why did they work? I knew it. 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 Hold on, y'all. Here go the verdict. So what we gonna do here is, I'm glad I moved it out the way. We're gonna do our verdict while we here. Hold on, y'all. They try to be slick. I hope he go to jail. Okay, hold on for a second. Let me put up your verdict. God, it's making my phone hot. Wow. Try to slip a tape in there. Okay, to be slick. Ooh, wait. Okay, y'all, let's see what the jury came up with, okay?
Very good afternoon. Everyone may be seated. All right, court is back in session on State versus Firriter. Let me have appearances, please. All right, court has been advised that the jury has reached a verdict. Are all sides ready to proceed? All right, Mark, you may bring the jurors out.
So scary, nervous. Nervous.
All rise. Jury entering. All right, everyone may be seated. All right, members of the jury, has the jury selected a foreperson? And that's you, Mr. Bushy? All right, Mr. Bushy, has the jury reached a verdict in this matter? No, you can just tell me yes or no, has the jury reached a verdict? All right, if you could please hand the verdict to my courtroom deputy. Madam Clerk, please publish the verdict.
In the Circuit Court of the 15th Judicial Circuit, Criminal Division in and for Palm Beach County, Florida, case number 22 CF 001136 BMB Division B. State of Florida versus Timothy Dunn Firriter. Defendant. Verdict. We, the jury, find as follows. As to count one, we find the defendant guilty of aggravated child abuse as charged in the information. As to count two, we find the defendant guilty of false imprisonment as charged in the information. As to count three, we find the defendant guilty of neglect of a child as charged in the information. So we say all this 12th day of October 2023 in West Palm Beach, Florida, signed by the jury foreperson.
All right, does either side wish to have the jury polled?
Yes,
All right, so ladies and gentlemen, there's been a request to have the jury polled, and that simply means that each of you will be asked the question of whether the verdict is your verdict or not. If it is, you should only answer yes. If it is not, of course, you should answer no and nothing further. So Madam Clerk, at this time, if you could please poll the jury.
Juror 1, were the verdicts as read your verdict? Juror 2, were the verdicts as read your verdicts? Juror 3, were the verdicts as read
Guilty,
your
brother.
verdicts? Juror 4, were the verdicts as read your verdicts? Juror 5, were the verdicts as read your verdicts? Juror 6, were the verdicts as read your verdicts?
All right, ladies and gentlemen of the jury, at this time, this concludes your service to your community in this matter. I want to thank you for the time and commitment that you've made to this case. It went a lot longer than I'd originally estimated. But in any event, I watched all of you during the course of the trial. You did exactly what I had requested. You stayed focused and tuned into the evidence during all phases of the case. And I hope everyone has a much better appreciation of the great responsibility that comes with serving as a juror in our community. So with that, I do want to thank you. My bailiff will give you a letter of thanks from me. Also, a certificate of appreciation from the Palm Beach County Bar Association, and a short little survey that I'll just ask that you return it when you get some time. Other than that, I do wish the best to all of you. And with that, you're excused. And Mark, you may escort the jurors out.
They did good.
Realtor.com is the #1 app real estate professionals trust. So when you're buying or selling a home, Realtor.com's Real Estimate gives you 3 independent valuations, so you know what a home is really worth. Real Choice Selling lets you choose.
Yes. Good. He don't sit down. He ain't gave them time up to leave. He mad.
All right, everyone may be seated. All right, Ms. Coakley, anything that I need to address as far as adjudication in accordance with the verdict?
He doesn't have a prior adjudication, but it is aggravated child abuse is a first-degree felony, so we'd request adjudication at this time. We'd also ask that he be remanded into custody at this time, pending sentencing.
Ms. Murad?
Your Honor, I would request that the court, as to him being remanded, he has been out of custody for 2 years without any issues or any violations of bond. If the court is inclined to remand him, my request is that the court put him on a monitor. He does have a place that he can live in Palm Beach County. He has no criminal record whatsoever, and he has no custody of any of the children.
Okay. All right. So the court, I'm going to adjudicate the defendant in accordance with the verdict, guilty of the charge of aggravated child abuse, guilty of the charge of false imprisonment, and guilty of neglect. At this time, I'm going to remand the defendant to the custody of the Palm Beach County Sheriff's Department. That's without prejudice for you to file any type of motion that you deem appropriate, Ms. Murad, for pretrial release or release during pending appeal. This ruling today is without prejudice for me to receive that and consider that at the appropriate time. Let me get an idea as to what the state is looking for in terms of a sentencing hearing.
I can do it as soon as the defense can be ready. He is entitled to a PSI. I don't know what the defense's position is.
Yes, Your Honor, this is a sentencing that I should be able to get done relatively quickly. Should the court have time in 2 or 3 weeks?
I'll make whatever time that I have to expedite sentencing if that's what both sides request.
That's fine, Your Honor. I won't need more than 20 or 30 minutes for my presentation.
All right, so Ms. Murad,
I would need an hour to hour and a half.
So I'm going to set aside 2 hours for sentencing, and Cynthia, let's pick a date on an afternoon for 2-hour setting. No earlier than 3 weeks out. That should be enough time for you to do what you have to do, Ms. Murad, but no more than 5 weeks. So in that 2-week period there, let's pick a 2-hour setting. All right, does that date work for everybody? November 16th for sentencing
Yes.
for the state?
All right, I can just have 1 second to get to that. Yes, you said Thursday or a Monday?
Thursday, November 16th.
Oh, I'm sorry. I'm
He
looking
thought
at
he was gonna get away with this.
Yes, that is fine with the state.
All right, so the sentencing of this matter is set for Thursday, November 16th at, what was the time, 2:30? 1:30, 2 hours reserved. All right, anything else that the court needs to address before we adjourn?
No, Your Honor, we are going to need to do a status. I know Ms. Marshall's in here. We're going to need to do a status check because I don't think we have a future date on Ms. Firriter.
Could we do it the same day as the sentencing?
That'd be fine, if you're good with
I
that.
might reach out to Ms. Marshall about having something having it next week so we can get.
Whenever you want to come in will be fine with me. The morning docket, as you know, is generally pretty heavy, so one more hearing is not going to make a huge difference. Okay. All right, so then that concludes the court's business today. I do want to thank both sides for a professionally presented case. We had a couple hiccups here and there, but over the course of an 8-day trial, that's to be expected. But thanks to both sides for the commendable job that each of you did. All right, thank you. Remanded 0 bond, but that's without prejudice for a subsequent motion to be filed. And if you have the orders on adjudication, I'll go ahead and sign those now. All right, so I'll remain here to sign the judgment and adjudication. that'll be fine. So I'll remain on the bench because I have a long walk back to my courtroom, so it's better I just stay here. You can, thank you.
Tell your husband about it. You know you glad your husband gone. He got on your nose. She ain't even crying.
Ghirardelli chocolate chip.
She ain't crying. She is not crying. She is glad. He probably got on her nerve. He is gone, honey. She about to go get her another man. Homegirl about to be through with him. Made that box for that boy. Oh, I'm sorry, y'all. And make that boy look like he was bad. They don't slip the tape back there, y'all. They slip the video back there so they see him getting handcuffed. The boy getting handcuffed. And the boy wasn't detained by the police officer. He just had a handcuff on scam.
Shaquille, is this the original or a copy?
All right, y'all. Let's discontinue. That's the verdict. Guilty. Boy in the box. Timothy Firriter. I guess that's his name. I really enjoyed y'all hanging in here with me. I did it, and you know, I did it while I was sick. And all I can tell y'all is I appreciate y'all. I appreciate y'all. He looks so relaxed now. At first, he was so intense. He was tensed up. I want to give a shout out to Court TV for doing a tremendous job, you know, with this trial. I appreciate y'all. Appreciate all the hard work and everything. So y'all, that end our section. The trial, like I said, the verdict was guilty. The boy in the box. And y'all have a good day.